Okay, people. Hello to all my ladies and my gentlemen and my aliens who are tuning in. This is the chosen one, the lonely Ronin, and I'm going to continue my dictation of the unsealed Ghislaine Maxwell documents, and I will skip over any formalities that I see in these documents. Let me get a ticker going, and maybe we could wait for some people to join. Actually, one of my subscribers, I learned, has a brother who is blind, who actually, I guess, listens to me sometimes, which that's pretty awesome to hear. So it's definitely motivating, to say the least, that someone like that is needing somebody to dictate this because they have interest in it, right? Or wanting to, right? Wanting it, not necessarily needing it. And I will continue where I left off before, which was on page 12. Excuse me, the top of 13. Okay, I'll just reread the testimony. Now, I understand from your testimony, and this is Miss Borja Dershowitz's lawyer. Now, I understand from your testimony that Mr. Edwards did not pressure you to give false information about this matter. Is that fair? Virginia Joffrey responds, that's fair. Tell me everything that Mr. Edwards told you about this matter. Miss Macaulay. Objection. That's privilege, and she has not waived any privilege. She's not here testifying as to what she discussed with her lawyers. You know, it's an interesting point. I'm going to grant your motion for privilege, but I'm going to suggest to you that there might be a strong argument to be made that those questions opened some of the door. I'm going to let the judge decide that. But you can go ahead, ask some questions. We'll put it on the record for later determination. It's going to force, to be blunt, this among other things that may force the witness to come back and complete the deposition. Let's just be aware of that. This testimony directly placed Virginia's attorney-client communications and work product at issue in the Dershowitz case. Edwards and Cassell took the affirmative position that Dershowitz's statements that Edwards and Cassell helped plaintiff fabricate her stories were false and defamatory. See Manager Declaration, XE part, page 2. Dershowitz went so far as to repeatedly accuse Edwards and Cassell, again, those are Virginia's lawyers, of criminal misconduct and actively suborning perjury and fabricating the allegations of misconduct against him, acts that would warrant their disbarment from the legal profession. Put simply, Dershowitz has made highly defamatory allegations that have no basis in fact. Communications between plaintiff and her attorney were a central issue in the claims brought by Edwards and Cassell, and plaintiff voluntarily testified regarding those communications. Plaintiff was acutely aware of how the information was being utilized in the Dershowitz case. According to plaintiff, Virginia, she is a party to a joint defense or common interest agreement with Messrs. Edward and Cassell. I can't believe they just used the word Messrs. When the Dershowitz case was filed, a mere week after the filing of the joinder motion on plaintiff's behalf, Edwards and Cassell represented plaintiff who Dershowitz had also threatened to sue. Thus, Edwards and Cassell allegedly act both as plaintiff's attorney and her joint defense or common interest partners. She was aware that what was, or in this case was allegedly not said between her and her attorney would be affirmatively used by her counsel/joint defense partners in support of their claims. She authorized the disclosure and testified, both with the assistance of Macaulay. Plaintiff, on behalf of her joint defense partners, provided evidence to support the factual claim Neither Edwards or Cassell nor anyone else asked plaintiff to lie about her stories of alleged sexual abuse and trafficking. The only way the truth of that issue can be tested is through the examination of all her communications about her stories with attorneys or otherwise. See Bound versus AIM-based corporation. So they're citing a previous court case. Otherwise, privileged communications put an issue where party asserts a factual claim, the truth of which can only be assessed by examination of a privileged communication. United States versus Bilzerian. Another case. So it goes on to explain the instances of this. A defendant may not use the privilege to prejudice his opponent's case or to disclose some selected communications for self-serving purposes. Thus, the privilege may implicitly be waived when defendant asserts a claim that in fairness requires examination of protected communications. In re von Bulow, it has been established law for 100 years that when the client waives the privilege by testifying about what had transpired between her and her attorney, she cannot thereafter insist that the mouth of the attorney be shut. So they're referring to attorney-client privilege. From that has grown the rule that testimony is to part of a privileged communication in fairness requires production of the remainder. United States for Schmidt. Okay, so they're saying, they go on to say the attorney-client privilege cannot at once be used as a shield and a sword. A defendant may not use the privilege to prejudice his opponent's case or to disclose some selected communications for self-serving purposes. The privilege may not simultaneously be used as a shield and a sword, i.e. both offense and defense, where a defendant opens the door by waiving the attorney-client privilege. The party cannot open the door only to the information he would like to admit. Plaintiff has used her attorney communications as a sword on behalf of her joint defense partners, and therefore her communications with her attorneys are no longer shielded. Plaintiff also testified that she shared her conversations and communications with Edwards to unrelated third parties. In particular, she shared a communications with a reporter for the Daily Mail Online, one Sharon Churcher. There is no doubt that sharing attorney-client communications with a third party, particularly when that third party is a member of the press, acts to waive any claim of privilege. Schaeffler versus the United States. Edwards and Cassell's waivers of attorney-client and work product privilege in the Dershowitz case. Okay, I'm going to move forward a little bit. Ms. Joffrey has submitted a sworn affidavit, not only attesting to the truthfulness of her allegations against Dershowitz, but also the fact that she told her lawyers about these claims. The assertions of sexual abuse are more than adequately corroborated by compelling circumstantial evidence which is detailed at length by Cassell in his deposition. Regardless of whether Dershowitz sexually abused Ms. Joffrey, Edwards and Cassell clearly had a good faith basis for relying on the sworn representations of their client. Edwards and Cassell had clearly conducted extensive investigation into the basis for Ms. Joffrey's allegations. The undisputed record evidence established is that Edwards and Cassell had every right following their detailed investigation to rely on Ms. Joffrey's credibility. The good faith basis for Edwards and Cassell's reliance on Joffrey's allegations is laid out in detail by Professor Cassell in more than 50 pages of sworn testimony during his deposition. Both Edwards and Cassell clearly had a powerful basis for believing their client's allegation that she had been sexually abused by Alan Dershowitz, particularly where she had made this allegation to them as far back as 2011. Dershowitz made false and defamatory statements by alleging that two experienced and capable attorneys, who thoroughly investigated and believed Miss Joffrey's allegations in good faith, should be disbarred. In addition to the motion for summary judgment, Mr. Cassell in his deposition spent more than 50 pages detailing the investigations and assessment of all the evidence used as a factual basis for the joinder motion in the CBRA case on behalf of plaintiff. During the soliloquy, Cassell details his and Edward's thought processes in assessing the claims, their evaluation of the evidence they reviewed, and all other information that he had to believe plaintiff's stories. He specifically refers to plaintiff, their evaluation of the evidence in light of the information they knew about plaintiff, and their evaluation and thought process of how the evidence supported her stories. Of course, the information they knew about plaintiff was a direct result of her attorney-client communications with them, and their evaluation of that evidence is, in this case, is clearly work product. In reciting the work product he believes supports Virginia's story, Cassell states that this is, quote, important to Virginia, and I want to do a good job for Virginia Roberts on representing all the evidence that is available to support her. Having put these matters directly at issue and utilizing both their, I lost my spot. Okay, here we go. As discussed above, courts have generally applied, okay, let me move forward a little bit. Okay. Plaintiff voluntarily and affirmatively waived the attorney-client privilege through her testimony. That alone is sufficient to find an issue waiver. She also permitted the waiver of the attorney-client privilege by permitting Edwards and Cassell to put her communications with them and her attorney's work product at issue with her full knowledge and consent. Plaintiff is a party to a joint defense agreement with Edwards and Cassell. She and her attorneys were involved in communication about the Dershowitz case beginning in January 2015. The case was preemptively filed to beat Dershowitz to the courthouse before he could act on his public statements that he had intended to sue both plaintiff Virginia Roberts and her attorneys for, among other things, defamation. Plaintiff did nothing to stop her counsel from filing the complaint, despite the fact that it would necessarily put her communications with her counsel at issue when she actively participated in the litigation. Indeed, the testimony of Cassell makes clear that the purposes of the litigation was for plaintiff's benefit and that he wanted to do a good job for her. Normally, an attorney cannot waive the attorney-client privilege without his client's knowledge and consent. This situation is analogous to a client asserting advice of counsel as defense, a situation at which an issue waiver of the full scope of attorney-client communications is automatic. And again, they quote the Bilzerian case. Defendant's testimony that he thought his actions were legal would have put his knowledge of the law and basis for his understanding of what the law required into issue. And this time they quote the Chin versus Rogoff case. Okay, I'm going to move forward a little bit. The application of the privilege here, after it has been selectively weighed, denies Ms. Maxwell information vital to her defense. By way of a very limited example, in the case at bar, plaintiff claims that she was defamed when Ms. Maxwell stated that the allegations plaintiff made in the joinder motion included allegations regarding Dershowitz, Ms. Maxwell, and Prince Andrew were false. In the joinder motion, Edwards and Cassell boldly state, quote, Epstein required Jane Doe number 3 to have sexual relations with Dershowitz on numerous occasions while she was a minor. Again, Jane Doe number 3 is Virginia. not only in Florida, but also on private planes in New York, New Mexico, and the U.S. Virgin Islands. Edwards and Casella, however, had doubts about plaintiff's allegations based on their own investigation, including whether Dershowitz and plaintiff were ever on Epstein's plane together. Well, that's interesting. Her own attorneys had doubts about her allegations, including whether Dershowitz and plaintiff were ever on Epstein's plane together. That is very, very interesting. Cassell identified flight logs Edwards and he reviewed as supporting the allegations made by plaintiff. Okay, I should have read the next sentence. He admits, however, that there is not... Oh, wait. Okay, I'm just going to shut up and read, guys. He admits, however, that there is not a single log entry that put Dershowitz and plaintiff on the same plane. Having put at issue their investigation and good faith belief in plaintiff's stories, they must provide all information about anything that both supports and undermines plaintiff's story and their own belief in the credibility of that story. So, end of paragraph. Now I'm going to summarize. So it says that basically her lawyers were not sure based on their own investigation whether they could believe Virginia, and they actually didn't find any flight logs that said she and Dershowitz were on the same plane, which I think is kind of interesting. Plaintiff, continuing. Plaintiff will undoubtedly, so again, the plaintiff is Virginia, attempt to prop up her claims that she was telling the truth through use of the investigative material, work product, mental impressions, and opinions on her credibility offered by her attorneys / joint defense partners, Edwards and Cassell. Ms. Maxwell cannot be denied access to information showing her attorney's work, and investigation shows plaintiff's stories were fabricated, including the details uncovered demonstrating her lack of credibility. Each of the factors considered by the Second Circuit to find a broad waiver weighs in favor of finding such a waiver here. The factors are whether substantive information has been revealed, and number 2, prejudice to the opposing party caused by partial disclosure. Number 3, whether partial disclosure would be misleading to court. Fairness, number 4, and number 5, consistency. Both Cassell and Edwards have revealed in extensive detail their work product demonstrating why they believed plaintiff's allegations and incorporated them in the joinder motion. So despite their investigations, they still believe Virginia. It would be prejudicial for plaintiff to be able to support her claim in this case that she is not a liar using her attorney's testimony and work product while preventing discovery of work product and communications that would otherwise or prove otherwise or cast doubts on her credibility. Okay, so we have from the deposition. My question, Mr. Cassell, is you reviewed the flight logs, correct? Correct. You reviewed them in some detail, correct? Correct. Is there any entry on those flight lines logs that you read as them to conclude that it was a mistake to have filed sexual misconduct allegations against Dershowitz. Fairness and consistency require that plaintiff and her attorneys be required to disclose all work product and attorney-client communications relating their investigation of plaintiff. Okay, I'm going to move forward a little bit. The next section is about stating that there is no privilege as to communications with Scarola, referring to Jack Scarola, who is the attorney for Edwards and Cassell. And again, Edwards and Cassell are Virginia's attorneys. So just so we keep that straight. I think I lost you guys for a second. Okay, I am on page 24. I'm at the conclusion, so I skipped ahead a bit past the section about Scarola, who again is Cassell and Edwards' attorney. Edwards and Cassell are Virginia's attorneys. Conclusion: plaintiff and her lawyers waived any privilege as to the communications related to the subject matters of the CVRA litigation and the Edwards and Cassell versus Dershowitz case. Similarly, her lawyers waived any claim of work product to material gathered in relation to those litigations. Accordingly, Ms. Maxwell requests that the court enter an order finding a waiver of the attorney-client privilege as the subject matter of the CVRA and Dershowitz litigations and a work product exemption for materials gathered in relation to those matters. She further requests an order directing plaintiff to provide Ms. Maxwell, Ghislaine, with all the documents as to which such the attorney-client privilege and work product have been waived. So what that means, as far as I can tell, is that Virginia is using information used via communications between her and her lawyers to attack Ghislaine. Ghislaine is saying that if you recall about the sword and the shield, that if you are going to do that, you have to expose all, she's arguing that you have to expose all of your communications if you're going to waive your attorney-client privilege. So she's requesting that the order, that the court finds a waiver of that and basically gets all of the documents that pertain to Virginia and her lawyers and their communications. That's what I am comprehending that as meaning. If we have any real lawyers in the audience and I'm wrong on that, please feel free to correct me. So that's the end of that. And now I'm on page 40. United States District Court, Southern District, New York, Virginia L. Joffrey, the plaintiff, versus Ghislaine Maxwell, the defendant. And first is the declaration of Laura A. Menninger in support of motion to compel all attorney-client communications and attorney work product placed at issue by plaintiff and her attorneys. I'm attorney at law, yada, yada, yada. Okay, so she is saying, I respectfully submit this declaration in support of Miss Maxwell's motions. The motions that I just said. And then it goes on to list the attachments as exhibits, some of which were filed under seal, some of which weren't. Looks like most were not. And I will move forward. Certificate of service again. So these that's formalities. Exhibit C. So this, I think we're getting to the fun stuff. Jane Doe number 1 and Jane Doe number 2 versus the United States. United States District Court, Southern District of Florida. Jane Doe number 3 and Jane Doe number 4's motion pursuant to Rule 21 for joinder and action. Number 3 and number 4, Jane Doe's, also referred to as the new victims, by and through undersigned counsel to file this motion pursuant to Federal Rule of Civil Procedure 21 to join this action, on the condition that they not relitigate any issues already litigated by Jane Doe's number 1 and 2, also referred to as the current victims. Again, Jane Doe number 3 is Virginia. So she's part of the quote-unquote new victims, according to this. The new victims have suffered the same violations under the the Crime Victims' Rights Act, as well as the current victims. Factual background. Moving ahead a paragraph or two. Page 46. As the court is aware, more than 6 years ago, Jane Doe number 1 filed the present action against the government, alleging a violation of her rights under the Crime Victims' Rights Act. She alleged that Jeffrey Epstein had sexually abused her, and that the United States has entered into a secret non-prosecution agreement, or NPA, regarding those crimes in violation of her rights. At the first court hearing on the case, the court allowed Jane Doe number 2 to also join the action. Both 1 and 2, specifically both Jane Doe number 1 and Jane Doe number 2, specifically argued that the government had failed to protect their CVRA rights. Again, CVRA is Crime Victim Rights Act, to confer a reasonable notice and to be treated with fairness. I think they're right. In response, sip. In response, the government argued that the CVRA rights did not apply to Jane Doe number 1 and Jane Doe number 2 because no federal charges had ever been filed against Jeffrey Epstein. What a racket, yo. The court has, that's not written in there. That was my commentary. The court has firmly rejected the United States position. In a detailed ruling, the court concluded that the CVRA extended rights to 1 and 2, even though federal charges were never filed. The court explained that because the NPA, the non-prosecution agreement, barred prosecution of crimes committed against them by Mr. Epstein, they had quote-unquote standing to assert violations of the CVRA rights. The court deferred ruling on whether the 2 victims would be entitled to relief, pending development of a fuller evidentiary record. 2 other victims, who are in many respects similarly situated to the current victims, now wish to join this action. The new victims joining at this stage will not cause any delay, and their joiner in this case is the most expeditious manner in which to pursue their rights. Because the background regarding their abuse is relevant to the court's assessment of whether to allow them to join, their circumstances are recounted here briefly. Jane Doe number 3. As with Jane Doe's 1 and 2, Jane Doe number 3 was repeatedly sexually abused by Epstein. The government concealed from Jane Doe number 3 the existence of its non-prosecution agreement in violation of her rights under the CVRA. If allowed to join this action, Jane Doe number 3 would approve the following. In 1999, Jane Doe number 3 was approached by Ghislaine Maxwell, one of the main women whom Epstein used to procure underage girls for sexual activities and a primary co-conspirator in his sexual abuse and sex trafficking scheme. In fact, it became known to the government that Maxwell herself regularly participated in Epstein's sexual exploitation of minors, including Jane Doe number 3. Maxwell persuaded Jane Doe number 3, who was then 15 years old, to come to Epstein's mansion in a fashion very similar to the manner in which Epstein and his other co-conspirators coerced dozens of other children, including Jane Doe's 1 and 2. When Jane Doe 3 began giving Epstein a massage, quote unquote, Epstein and Maxwell turned it into a sexual encounter, as they had done with many other victims. Epstein then became enamored with Jane Doe number 3, and with the assistance of Maxwell, converted her into what is commonly referred to as a quote-unquote sex slave. Epstein kept Jane Doe number 3 as his sex slave from about 1999 through 2002, when she managed to escape to a foreign country and hide out from Epstein and his co-conspirators for years. From 1999 through 2002, Epstein frequently sexually abused Jane Doe number 3, not only in West Palm Beach, but also in New York, New Mexico, the U.S. Virgin Islands, in international airspace on Epstein's private planes, and elsewhere. Epstein also sexually trafficked the then minor Jane Doe, making her available for sex to politically connected and financially powerful people. Epstein's purposes in lending, quote unquote, Jane Doe along with other girls to such powerful people were to ingratiate himself with them for business, personal, political, and financial gain, as well as to obtain potential blackmail information. Some of this is redacted. God dang it. One such powerful individual that Epstein forced then minor Jane Doe number 3 to have sexual relationships with was blankety blank blank blank, redacted. A close friend of Epstein's, redacted. Epstein required Jane Doe number 3 to have sexual relations with, redacted, on numerous occasions while she was a minor, not only in Florida, but also on private planes in New York, New Mexico, and the U.S. Virgin Islands. In addition to being a participant in the abuse of Jane Doe number 3 and other minors, redacted, was an eyewitness to the sexual abuse of many other minors by Epstein and several of Epstein's co-conspirators. Redacted would later play a significant role in negotiating the NPA on Epstein's behalf. So I'm guessing that's Dershowitz, yeah? Wasn't that his lawyer? Indeed, redacted, helped negotiate an agreement that provided immunity from federal prosecution in the Southern District of Florida, not only to Epstein, but also to any potential co-conspirators of Epstein. Thus, redacted, helped negotiate an agreement with a provision that provided protection for himself against criminal prosecution in Florida for sexually abusing Jane Doe number 3. That's ridiculous. Because this broad immunity would have been controversial if disclosed, redacted, along with other members of Epstein's defense team, and the government tried to keep the immunity provisions secret from all of Epstein's victims and the general public, even though such secrecy violated the Crime Victims' Rights Act. I'm going to take a break and look at comments here, guys. What's up, Slim Jim? I need a sip, too. I got to catch my breath for a second. What do you guys think of Emmett's comment? He says a lot of these grown women who are in the lawsuits currently already received settlements with Epstein and shouldn't have been included as victims. They were not victims. Many were not even children. They were grown women and made their own choices, like Sarah Ransom and Shantae Davies and Maria Farmer and many others. They were complicit. Brittany Pablo says, funny how the big-time names are blacked out. We all knew this was going to happen. That was going to happen. As you guys can see, I relapsed on my caffeine, but looking back on the track. Ghislaine Maxwell was another person in Epstein's inner circle and a co-conspirator in Epstein's sexual abuse. She was someone who consequently also appreciated the immunity granted by the MPA for the crimes she committed in Florida. Again, MPA is non-prosecution agreement. In addition to participating in the sexual abuse of Jane Doe No. 3 and others, Maxwell also took numerous sexually explicit pictures of underage girls involved in sexual activities, including Jane Doe No. 3. She shared these photographs, which constituted child pornography under applicable federal laws, with Epstein. The government is apparently aware of, and in certain instances, possesses some of these photographs. They probably possess all of them. That's my opinion. Perhaps even more important to her role in Epstein's sexual abuse ring, Maxwell had direct connections to other powerful individuals with whom she could connect Epstein. For instance, one such powerful individual Epstein forced Jane Doe No. 3 to have sexual relations with was Redacted. Jane Doe No. 3 was forced to have sexual relations with Redacted when she was a minor in 3 separate geographical locations. Okay, I'm guessing this is Prince Andrew. In London, at Ghislaine Maxwell's apartment in New York, and on Epstein's private island in the U.S. Virgin Islands, in an orgy with numerous other underage girls. I guess it isn't necessarily Prince Andrew, but it probably is, right? Epstein instructed Jane Doe No. 3 that she was to give Redacted whatever he demanded and required Jane Doe No. 3 to report back to him the details of the sexual abuse. Maxwell facilitated Redacted acts of sexual abuse by acting as a madame for Epstein, thereby assisting in an internationally trafficking Jane Doe No. 3 and numerous other young girls for sexual purposes. Another person in Epstein's inner circle of friends, who becomes apparent with almost no investigative effort, I can't believe they wrote that, is Redacted. Epstein sexually trafficked Jane Doe No. 3 to Redacted many times. Redacted was another of Epstein's closest friends and a regular traveling companion who had many contacts with young girls throughout the world. Redacted has been a model scout, okay, so this is John Luke Brunel, I'm guessing, for various modeling agencies for many years, and apparently was able to get U.S. passports for young girls to quote-unquote work as models. He would bring young girls, ranging to ages as young as 12, to the United States for sexual purposes and farm them out to his friends, especially Epstein. Redacted would offer the girls quote-unquote modeling jobs. Many of the girls came from poor countries or impoverished backgrounds, and he lured them in with a promise of making good money. Epstein forced Jane Doe No. 3 to observe him, Redacted, and Maxwell, to engage in illegal sexual acts with dozens of underage girls. Epstein also forced Jane Doe No. 3 to have sex with Redacted on numerous occasions, at places including Epstein's mansion in West Palm Beach, Little St. James Island in the U.S. Virgin Islands, many including orgies that were comprised of other underage girls, New York City, New Mexico, Paris, the south of France, and California. Epstein also trafficked Jane Doe No. 3 for sexual purposes to many other powerful men, including numerous prominent American politicians, powerful business executives, foreign presidents, a well-known prime minister, and other world leaders. Epstein required Jane Doe No. 3 to describe the events that she had had with these men so that she could potentially blackmail them. The government was well aware of Jane Doe number 3 when it was negotiating the MPA, as it listed her as a victim in the attachment to the MPA. Moreover, even a rudimentary investigation of Jane Doe number 3's relationship to Epstein would have revealed the fact that she had been trafficked throughout the U.S. and internationally for sexual purposes. Nonetheless, the government secretly negotiated a non-prosecution agreement with Epstein, precluding any federal prosecution in the Southern District of Florida of Epstein and his co-conspirators. As with Jane Doe number 1 and number 2, the government concealed this NPA from Jane Doe number 3, all in violation of her rights under the CVRA, Crime Victims' Rights Act. To avoid Jane Doe number 3 from raising powerful objections to the MPA that would have shed tremendous public light, I'm turning British, schedule, on Epstein and other powerful individuals, and that would likely have prevented it from being concluded in the secretive manner in which it was. Oh, now we're talking about Jane Doe number 4. This is a new development. Time for a sip. If permitted to join this action, Jane Doe number 4 would allege, and could prove at trial, that she has CVRA claims similar to those advanced by Jane Does 1 and 2 based on the following. As with other Jane Does, Jane Doe number 4 was repeatedly sexually abused by Epstein. In or around the summer of 2002, Jane Doe number 4, an economically poor and vulnerable 16-year-old, was told by one of Epstein's other underage minor sex abuse victims that she could make $300 cash by giving an old man a massage on Palm Beach. An acquaintance of Jane Doe number 4 telephoned Epstein and scheduled Jane Doe number 4 to go to Epstein's house to give him that massage. During the call, Epstein got himself on the phone with Jane Doe number 4, asking her personally to come to his mansion. Jane Doe number 4 then went to Epstein's mansion, as was escorted upstairs to Epstein's large bathroom by one of Epstein's assistants, Sarah Kellen perhaps. Shortly thereafter, Jeffrey Epstein emerged and lay face down on the table and told Jane Doe number 4 to start massaging him. Epstein asked Jane Doe number 3 her age, and she told him she had recently turned 16. Epstein subsequently committed illegal sexual acts against Jane Doe number 4 on many occasions. Epstein used a cell phone to arrange for these sexual encounters. I don't know, they call it a means of interstate communication. I don't know why they just don't say cell phone. Epstein also frequently traveled in interstate commerce on his personal jet for purposes of illegally sexually abusing Jane Doe number 4. What is missing? Something is missing. It just says January on the next page. That's weird. Okay. I'm going to go to the conclusion. Jane Does 3 and 4 should be allowed to join this action pursuant to Rule 21 of the Federal Rules of Civil Procedure. Respectfully submitted by Mr. Bradley J. Edwards and Paul Cassell Pro Hoc Vice, which basically just means that he is operating out of his licensed jurisdiction of jurisprudence. Okay, let's check the comments. That was exhibit, end of the exhibit. That is a good point. And it's a legal quagmire because some of these grown women not only were trafficked, but also were madams as well. Like Sarah, I don't know if Sarah Kellen was trafficked, but I mean, look, I mean, if you're an adult, you should take responsibility for your actions. That's my opinion. But let's go on to the next exhibit. H. In the Circuit Court of the 17th Judicial Circuit in and for Broward County, Florida, Bradley J. Edwards and Paul G. Cassell, the plaintiffs, versus Alan M. Dershowitz. Videotaped deposition of Virginia Roberts Joffrey. This happened on the 16th of January, 2016, from 9:07 a.m. to 2:48 p.m. at 401 East Los Olas Boulevard, Suite 1200, Fort Lauderdale, Florida, 33301. Confidential, confidential. Miss McCauley. Yes, I do. So let's take a break. Okay, again, there's pages missing here. A recess was taken. Okay, here we go. Just for the record, this is a special master, redacted, through counsel examined the witness for 4 hours and 7 minutes, and there was a request, and it appears to be in agreement to allow. Mr. Scott says no agreement. Special master says, hang on 1 second, hang on. Between Mr. Scarola and Miss McCauley, to allow Mr. Scarola a couple questions on examination and cross, and then my ruling is going to be as follows. Excuse me. Go ahead and ask whatever questions you want, Mr. Scarola, at which time I will give opportunity for redirect based upon the topics you've raised. Mr. Scarola says, with the understanding that redirect is going to be limited to the area of inquiry that I'm about to conduct. I'm about to conduct an inquiry. Thanks for that, Scarola. Special Master says, this is the understanding. My understanding of my ruling. I know that redacted team has objected to that. I also understand that there might be, this is no impact or the right or anybody else's right to go back to Judge Lynch and ask for more time from this witness based upon my ruling or my reading of the original order. There's also the motion to strike the testimony they allowed over the ruling. There's a series of those things that might need to be cleaned up in a subsequent sitting. Cross-examination. Okay, I'm skipping Special Master. Let's rock and roll. By Mr. Scarola. Virginia. Has Brad Edwards ever pressured you or encouraged you in any way whatsoever at any time and under any circumstances to provide false information about redacted? Never. Has Brad Edwards, I'm guessing that's Dershowitz, ever pressured you or encouraged you in any way or under any circumstances at any time to provide false information about Jeffrey Epstein? Never. Has he ever pressured you or encouraged you at any time or in any way under any circumstances to provide false information about anyone or anything? Never. Has Paul Cassell, again, same questions, she says never, she says never. Miss Borja, and that's Dershowitz's counsel. Objection. I couldn't follow who he was. Mr. Scarola. Mr. Castle, Professor Cassell, you understood that I was asking you that question about Professor Cassell, right? And he's never pressured me or encouraged me in any way to talk. Miss McCauley then cuts off Virginia. I don't want you to go into discussions with them if you're saying something didn't happen. Special Master, just Miss McCauley cuts off Special Master. I'm preserving privilege. I just want to make sure if something didn't happen, she can say that. Mr. Scarola asks Virginia, has Professor Cassell ever pressured you or encouraged you in any way to provide false info about anyone or anything at any time? Never. Apart from efforts made by Jeffrey Epstein or agents on behalf of Jeffrey Epstein to silence you, or have you refrained from providing true and accurate information about the interactions that you had with Jeffrey Epstein and others to whom you were trafficked by Jeffrey Epstein? This is a mouthful. Has anyone apart from that circumstance pressured you or encouraged you to provide false info about any of the topics that were covered during the course of your examination? Ms. Borja says, objection. Objection to the form. Leading, assumes facts not on evidence, compound, misleading. Your form objection will be reserved. You can answer. Virginia says no. Scarola, thank you. I don't have any further questions. Mr. Scott says, Judge, excuse me, none of this was covered on direct examination, so we move to exclude and strike the entire testimony because none of this was covered on our direct. But we would like to request a 2-minute recess because these are completely new areas. I'll grant your 2-minute recess. You spelled grant wrong. Going off record, recess taken. Redirect. Okay, I'm skipping ahead to the examination. And this is Miss Borja this time. Before you were scheduled here under oath today by Mr. Scarola, did you talk to him in the break room? Ms. McCauley, objection. To the extent you discuss privileged information with your lawyers, you don't have to reveal. Ms. Borja responds, I'm asking what she talked about with Mr. Scott. Ms. McCauley says she's in a joint defense agreement with Mr. Scarola. Ms. Borja says, are you in a joint defense agreement with Mr. Scarola? Mr. Scarola responds, I will tell you that there is a joint defense, a common interest privilege agreement between the witness and my clients. Yes. Are you asserting that privilege? Says the special master. Yes, says Scarola. We are asserting that privilege and instructing the witness not to answer on the basis of the privilege that exists for Mr. Edwards and Mr. Cassell. So I'm guessing they're referring to the attorney-client privilege. Special master says, so with what I'm going to grant the motion, similar to what I did the other day when redacted, was testifying and under the reservation that can be dealt with later in front of the judge or in front of me, whichever you choose. Now, I understand from your testimony that Mr. Edwards did not pressure you to give false info. Is that fair? That's fair. And that was Ms. Borja asking Virginia. She continues, tell me everything that Mr. Edwards told you about this matter. Ms. McCauley says, objection. That's privilege, and she has not waived any privilege. She's not here testifying as to what she discussed with her lawyers. You know, it's an interesting point, Special Master. I'm going to grant your motion for privilege, but I'm going to suggest to you there might be a strong argument to be made. Okay, so I said this earlier, actually. I think it was, I think I repeated actually at the beginning of this video. I'm going to let the judge decide that, but let's come back to it because there's a strong argument to be made there. Let's be aware of that. And I can't make a proffer to all of my... A proffer is an offer to all my questions because some of them will depend on this witness answers. Special Master, I'm aware of that. Ms. Borja, I want the record to be clear that although I'm being asked for a proffer, I'm constrained based on my inability to follow up. Special Master, I understand that. But I'm sure that you have a couple questions that you'd like to proffer to give the record an idea of where you might have gone without restraint to what the answer might be, and then a subsequent question might lead from that answer. I understand that. These people are good with words. By Ms. Borja. Did Mr. Edwards ever suggest to you anything regarding redacted? Ms. McCauley. Objection. Hang on, I'm objecting. She's making a proffer, and I need to make my objection on the record. Do not answer. Objection. Attorney-client privilege. So I'm going to grant within the reservation to be brought back later. Ms. Borja, did Paul Cassell ever tell you anything about the topics that were covered in today's deposition? Ms. McCauley, objection. Attorney-client privilege. Special Master, same ruling. Ms. Borja, did anyone from Boise, Schiller, ever tell you anything about the topics covered in today's deposition? Ms. McCauley, objection. Privileged work product. Special Master, same ruling. Ms. Borja says, did Mr. Scarola ever tell you anything about the topics that were covered in today's deposition? Ms. McCauley, again, objection. Attorney-client. End of exhibit. All right, guys, I'm getting tired. I'm going to have to take a break. I will probably resume in a couple hours at the most with the next exhibit. But I've been going about an hour now, nonstop. So if you guys like this stream, let me know. If you have suggestions, please let me know as well. If you are just discovering my channel, I have a bunch of interviews with people. That's my principal main focus is interviews, but I also do general news commentary as well. And I'm just trying something new out here by reading out the unsealed Ghislaine Maxwell documents. And again, I will start with the next exhibit once I stream again. I would say within a couple hours at the very latest. I just need to take a break and let my voice rest for a little bit. If you like this, please subscribe. It's free to do so. Maybe you can hit the like button, and if you really like it, maybe think about becoming a Patreon. You can do it for $1, $2, or you can make a larger donation to GoFundMe or something else. Links are in the description box below. Shout out to Quadrix for being an awesome mod. And that is my Patreon. And I do see your comments there, Emmett. I actually was discussing that with one of my other subscribers, a woman whose name I won't say. But it's a touchy subject for sure. Definitely is. And I'm just going to let other people discuss that. I'll let you guys discuss that. I'm going to kind of try to keep my opinions to myself as far as that goes. Again, all I'll really say is that I think adults should take responsibility for their actions. But again, if you guys like the stream, go ahead and sub. It's free to do so. And if you really like, support me on Patreon. All right, guys, I will again continue with the next exhibit later this morning. Cheers. All the best. Stay frosty from the Midwest. Until next time.